Okay, welcome everyone. We'll start our lesson 3 and lesson 4 tutorial. My name is Anjum Sathar and my email address anjum@ukversity.co.uk. If you have any question, please drop me email. I'll go through with you if any question you have. So LO3, which is about understanding the YT18 elements that affect the validity of the contract, which we'll go through what those elements which can terminate the contract. And that's, those are crucial to know as a contract management point of view. In a business, we have to deal, various sort of contract. Okay, so we'll check how much we know about contract law or misrepresentation. What do you think? Where at the moment your current knowledge? Based on the previous lesson, we learned about contract law and we learned about 7 elements of contract. Do we remember? Yes, Mary, what do you think? If you reflect, 1 to 10, what do you think? How much we know about contract? Is it 3, 4, 5?
Maybe 5.
Maybe 5. Okay. So last lesson we discussed about contract. We discussed about contract is an agreement. Yes, is a legal binding. We discussed, there should be a consideration. There should be a sound mind. There should be their offer and acceptance. If there is no offer and acceptance, there won't be any contract. Yes, and we discussed contract can be written, contract can be oral, all this. So today lesson is about misrepresentation, elements of misrepresentation, different case laws about misrepresentation. So all will be focused during today lesson. So first types of misrepresentation, we can misrepresent, saying things different, actually not. There are various things. So normally is anyone heard about, have we heard about ISO 9000, 14,000? Have you ever heard?
No.
This is ISO is called International Standard. Basically, this is standard organization who set the quality standard. Quality standard. So it's all about what we are saying. What we are saying, same thing we are doing, and we have documentary evidence. So this is called ISO 9000. So first, if we are saying things and then actually we're not doing, we're saying this is a wonderful product. This, let's say L'Oreal cream for face will, protect you from various wrinkles and things, So actually it's not. And this contains this ingredients, but actually not. So it's a misrepresentation, yes? So we're not really telling the truth. We should be. So that can be. So this is a one of organization who give the certificate to various organizations. They say, oh, this company is a good for quality. Yes. And the people have a trust, like a trust pilot maybe you use. Have you used trust pilot? Like, where we can see if we want to buy anything online, we can read the different people view, and we can look up. So this is all about, ISO is the organization give the quality certificate, and the companies advertise on the media that this is ISO 9000 we certified. So they have a certification. So fraudulent misrepresentation is a part make the statement knowing it is not true. I know this is not true, but I'm telling people is it true. Yes. So this is a misrepresentation. Other is called negligent. Misrepresenting, a party believes the statement to be true but has no reasonable grounds for the belief. Yes, there are no particular grounds. Third, innocent. Innocent, false statement of fact made by the party who had an honest and reasonable belief it is true. Yes, who have believed is a true but actually it's not. Yes, so they are innocent. So fraudulent, negligent, and innocent. These are three types of misrepresentations. Then we have a remedies of misrepresentation. Recessions, which is means set the contract aside if the party had never entered into the contract. Damages, fraudulent misrepresentation, innocent party entitled damages for losses they suffered. Damages based on the tort or deceit. So that is meant by, we have to pay the damages to the party who had injured party who had bear the losses. Negligent misrepresentation, innocent party entitled to damages under Section 2.1 of the Misrepresentation Act 1967. So if we don't follow the legislation, it can lead to the criminal. What we said, civil is a private matter where the damages come, but the crime and the criminal activities leads to if we don't follow the legislation. Innocent misrepresentation, recession, and the damages under the Misrepresentation Act 19 is the court decide that award damages are most appropriate remedies to compensate individual, which is called injured party. Misrepresentation exclusion clause inserted to be exclude the fraudulent misrepresentation invalid, but the negligent and innocent representation is possible reasonable under the Misrepresentation Act. Okay, mistake. Yes, we can make mistake, common mistake, where both parties make same mistake. Mutual mistake where both parties are at the cross purposes. And unilateral mistake where one party is mistaken and the other party is aware of the mistake. Unilateral. Yes? Any question here? Yes, Mary? Any question if you have?
The previous slide, it said on the notes SRA. I don't know what that means. That makes sense.
Sorry, which one?
The previous slide you went to, it says SRA at the bottom.
ISO.
No, yeah. The other one forward. The other one.
Oh, you meant by SAR.
Yeah.
Okay, yeah. This is the solicitor. It's regulatory.
Okay.
Authority, yeah.
Okay.
Who regulate? So authority, yeah.
Yeah.
So who regulate? So if you're dealing with the solicitor firm and they're not treating you well, you have a right as an individual to complain SRA. Yes?
Yeah.
Called the regulatory, solicitor regulatory authority. They give license and they can revoke their license to practice. It happen various solicitors, they're not, So that's why they're very keen to get your signature first. Every document they want. Okay, next we have a term is called duress, where the party has entered into the contract after the other party has threatened the physical violence and the serious economic costs. Yes, so we need to be look around. Serious, yes, can be economically losses. Undue influence. What is meant by undue influence? Like boss undue influence with the junior staff. Yes, we have a contract, but we don't have a contract. Of course, we can't keep any other relationship than except employment relationship. Yeah. So if somebody undue influence, this is a violation of the contract law itself, and that leads to be the criminal activity as well. Can make a contract voidable. Contract can be finished itself if we influence. You must have to do. Yes, in here, if somebody don't understand the proper, you must have to do is the law. You have to do, but actually we're telling the lie. Misrepresentation, yes, can occur where the parties has entered into contract and after excessive persuasion has been applied by the other party. Presume where there is a relationship of trust and confidence. Any question here?
No.
Okay. Illegality. Illegality, these contracts will not be enforced by the courts. They may be illegal because of the type, their purpose, or because of the manner in which they have to be performed. Any contract which does not break the law but against the public interest must be illegal. Nothing written in the law, yes, but is a harm to society. Let's say there are the certain things, let's say for wheat, or various other drug related. Maybe in the law is not forbidden, but is morally is not correct and legally is illegal to do. Yes, even not written it. So we can break, yes, which is harm the individuals, their morals. So we have a 3.1, identify the elements of actionable misrepresentation. A misrepresentation is form of statement made prior to the contract. Yes, two types of can be form, part of the contract and not part of the contract. They're becoming a misrepresentation. Misrepresentation is the false statement. 16 facts made by one party to another party, which violates not the term of the contract, induce the other party to enter into the contract. An actionable misrepresentation must be false statement of fact, not of the opinion or the future intention of the law. Silence does not normally amount of misrepresentation. However, representator must not misleadingly tell one party of the truth, and thus the statement does not present the whole truth, maybe the misrepresentation, where the statement was true when it was made, but due to the change the circumstances become false, and there is a duty of disclosure the change. Any question?
No.
I was in a good health, but suddenly health changed, so technically should we declare it? Misrepresentation may be fraudulent, made knowing without belief in its truth, or reckless. Negligent may be a person who had no reasonable grounds believe that it was true. Yes, that can be, and that leads to the break contract. Then we have 3.2, where we're looking the difference between fraudulent, negligent, and innocent. Like at the top, we discuss about what is three misrepresentation types. Fraudulent misrepresentation, significant misrepresentation, classified as fraudulent. Representee should attempt to be claimed the fraudulent misrepresented with the caution as the court impose highest standard of proof due to the seriousness of allegation. And may also be penalties in the events that the claim is not being made out. The reversity in that case, yes. This is a case law, false statement which is made knowing without belief in its truth. Rigorous. Careless, yes, whether it's true or false. In order to assess whether the statement has been made fraudulently, you should consider whether the statement made knowing that the statement has been made false. The statement maker has reasonable ground belief. Yeah? That's also we need to be in case there will be a clearly fraudulent statements. So that's always we need to be. Any question, Mary, here?
No.
Okay, always we need to be morally correct, yes. Of course, sometime in the real world, maybe interpretation people can be different. So we try to be people good understander. So that's why sometimes the bank says data protection, you understand this, huh? Sometimes we say yes, but maybe we not 100%. So that's why they send you a document. So clarified in this is the case, the statement where they make no idea whether or not false or true, the fraudulent due to the rigorous assessing truth. There can be true statement which is become false, and that this is the case that happened back in 1936. There was a negligence, yes, not being. Duty of care is all about. Like in the past, PPI. Do we know PPI? Yes.
No, I forgot.
Payment protection insurance. Many people claim back. Yes, the
Yeah.
money paid. So that bank was knowing this is the buyer don't need to buy it, but bank enforce it. They not give you the loan until you don't buy the PPI insurance. Yes. So that's why the watchdog decided whatever the PPI you paid, you are entitled to get back from the bank. Yeah, that's why the PPI, company payment protection, they work on the behalf of you and they offer these refunds. So this is all about a negligent misrepresent. This is one other case laws we can look around. Yes, different case laws. So when we write assignment, so we can write what is the negligent misstatement, a claim of the negligent misrepresentation, which is based on the tort under the common law is usually referred as the negligent misrepresent. Yeah, like in that case, that's the case law which we can include some cases. Okay, negligent misrepresentation, altered approach to the claim. The negligent misrepresentation pursue the claim under the statute, law. We can under these laws, and these people they claim it in the past, and court decided in their favor. Innocent, as we discussed earlier, where the Development of Misrepresentation Act is innocent misrepresentation is extremely limited. A claim of innocent misrepresentation will arise when the claim is negligent misrepresentation under the Act has failed, so that can be innocent party is entitled. And then we have 3.3, which is assessment criteria analyze. So when you do analyze this stuff, so look around duress, what is meant by in the contract related where the person enter into agreement as the result of the threat. We're giving threat. You will lose, yes. Undue influence, yes. Party enter into contract because the duress and may have the contract set aside. Originally, the common laws only recognize the threat of unlawful physical violence. But no, it's not just a physical violence. Just by threading, you will go loss or will take you court. Economics duress. It means economically, yes, valid the claim you're entitled. Hating factor that the contract absence of the free consent. We should be free consent avoidable. Contract can't be enforced by law if it's influence. Undue influence, yes, your position, your power, like in some culture, male influence, yes. So some culture, so that's we not because in the law is equality. Undue influence divide into actual undue influence and presume undue influence. So if that happen, the contract can be void. That can't be enforceable. Duress to the person where the person enter into the contract as a result of the physical violence may be set aside the providing threat. So there are the case laws which is happen and the people claim it. Duress of goods is not recognized as given the rise of the grounds of the contractor side. However, the decision has received the widespread of criticism outline of statutory claim. So that's the claim is happen. Economics, yes. So where we can entitle the people to claim. These are the case laws between individual, the other party manage to claim the money damages to other. This is economics. Privacy of the counsel identify four factor consider assessing the economic. Did the person claiming to be protest, yes, and did the person have an available course of action? Where the independently advised, is it the independent advice being independent awarding bodies or independent, the watchdog, which is one of watchdog is called ombudsman. If we have any problem with the companies, so we can complain to the ombudsman. So that is one of the watchdog. So that they provide the independent advice, and they also guide you what, yes, legitimacy of pressure we can't really do in the law. Okay, illegitimacy of the pressure initially was the thought the threat must be unlawful. So we need to be look around these laws case laws we can include when we write assignment, effect of finding duress, yes, since Okay, any question?
No.
Okay, then we have a merit criteria. When it's come merit, if you want to get merit, so we have to address these, we have to explain these terms in our assignment. Examine their remedies: fraudulent, negligent, innocent. So we can explain what is meant by these three, and what recession, when the contract has been induced by the misrepresentation. Any kind of contract still confer obligation upon the parties, but the contract will be voidable. Yes, not anymore. Voiding the contract is the stage where the remedies of recession, and these are the number of restrictions to be used for this remedy, and this is known as bar 2. So that can be affirmation. So is referred to the contract where the despite the misrepresentation, representee had held themselves out to be happy with the contract. Yes. In that case, that was the case law was to happen, other party claim, the judge claim. So these are known as the case laws. Yes. So case law is mean not a written law, but we can realize what is happening other people, and that become the case, and we can use in the court as a case law. English law is more based on the case law. Huh? There is not happy with the contract, and there will be action of remedies of the contract. Any question here?
No.
FC of time. So there is a different approach of the code, different types of misrepresentation, and the time to time and fraudulent representation. FC, the time it began, the time of fraud, which is they discovered or could have been discovered, maybe not discovered. So an innocent party can be, and their damages can be with the passage of time, can be how long you are. That's the things happen. Institutions in Tigrum. So the bar recession refer to the recessions. In that case, the contract is no longer be passed. Yes, contract can't be void. Yes, we can't really deliver the goods. Yes, we said it, but actually we promise it. Third party interest may be, yes, where the recession would be in on the rights of the third party. Yes, remedies to be unavailable. Third parties, fraudulent representation. These are the case laws to be, if we include and more compare and contrast under the, then of course we'll get the merit. And if we want to work the distinction criteria, this is also for merit: misrepresentation and types of mistake in the contract. Yes, mistake by fraud. Yes, we are doing a mistake intentionally, unintentionally mistake, indemnity. Yes, and then we have a common mistake, four type: mutual mistake, unilateral mistake, and mistake by identity. We giving the wrong. Yes, mistake at the existence of the subject matter, mistake of title, mistake of quality, mistake of possibility. Also in these cases then leads to be unilateral. Yes, one side and other side know this is the mistake, but other side don't know, and then of course need to be unjustified. So these are some case laws which is being referred to, and the damages that the parties are entitled. So I copied the video as well, so it's good to be watched in your own time, please. I copied the link to play the Kahoot quizzes. I copied the links, the possible resources on these terms, and then here is copy the links, and please, further if you want to read it, background, you can. This was the lesson 3, and now we can go through LO4. Any question? Mary, we okay?
The links that you mentioned there. Can we also use in the assignment?
Yes, you can use it, and you can put it access date, and you can cross-reference it, which I further demonstrate during our assignment discussion lesson as well. Yes, you can.
Okay.
Okay. Next, we're looking. LO4 is a discharge of contract. How contract can be discharged? Huh? So like I gave you example about 0845 numbers. You have a contract with the mobile company, and they said initially 0845 numbers will be free, and then they send you letter 0845 numbers will be chargeable. So as a customer, as a client, we are entitled to be terminate my contract. Yes, because they're not provided, good not fit for purpose, Sales Good Act, which I mentioned in 1974 allow us. Yes. Okay, here we're looking the breach of condition, warranty, and terms. If you breach its contract, will be terminate and discharge. So you can, we know warranties, we know terms of the contract. So this is the indicative content what we read. Yes, what is a contract? Contract, in the lesson 1 as well, in the LO1 we also mentioned, is a legal binding promise, yes, written or oral, by one party fulfill the obligation to another party, is called consideration. Valid contract is one meets the basic element of the contract. Contract is a valid, it can be voidable contract, provide the option to reclaim by either party, and the creation of the contract, it is a valid that it could be voided in the future. So where is the essential element? There we discuss, there should be offer, there should be acceptance, there should be consideration, there should be sound mind, there should be agreement. Then, if we can't really perform, explain the way in which the contract can be come to end. Here are the 4 types of the contract can be end. By performance, whatever we agree, we done your work, we perform is contract finished. In future, we're not responsible for it. Like between builders. By agreement, the parties agree to end the contract by agreement. Yes, both parties agree to finish the contract. Breach of contract. The innocent party has the right of termination of breach of contract. When party does not deliver what was promised and is in the repudiatory breach, yes, another is the agreed standard of breach. Yes, that's 2. The 4th one, by law of frustration. Underlying circumstances of contract change which material alter performance requirement of contract. Any question here?
No.
So termination of performance, when the both parties of the contract have performed all the obligation under the contract, including express and implied terms, come to end. Each party have performed their obligation. Of course, it can be, and the contract is fixed time. Yes, 2 years. It can be finished after 2 years. Like mobile contract, you have a 1 year contract, then you move the standard tariff, and you have a right to terminate whenever you want to, because you're not anymore in the contract. Actually, you was agree in the contract. It can't be automatically renewed into you becoming again 1 year contract. That can't be. It should be, the company should be inform you the new obligation, and you should be agree. If you don't give the consent, that's sometimes company write you like insurance for next year will be this, and automatically you enter into the new contract, but they gave you the time as well to accept it or reject it. So deviation from the contractual obligation with the amount of the breach of the contract, like is happen in Bolton and DVR. So that's the contractor is required to install the central heating. These are the one of the case law. Yeah? The court finding there, so we can, it's a payment, so we can include each type of example in the case law. There is a IT consultant, and this is also case law. Huh? So these are the lot of case laws we included in the slide, so we can include in some. So that's termination of agreement. Yes, agreement is always parties to be agreed to variation. If variation, if we not agree, one party do, other party not consent, it can be variation, it can be terminate, like which I mentioned you 845 numbers example as well. So legal binding, variation of. So agreement for the legal binding, there must be either the fresh consideration. No, we are agree on the new term. Yes, we are entitled 5%. No, we'll give you 3% because the economics environment changed due to the COVID-19. We said 7 days we'll deliver you good, but now we'll deliver you in 20 days. Yes, it's not our control. We have a new term and new variations. The old contract can be superseded with the new contract. Huh? A promise. So that's we need to be apply in that, and we have a lot of the case laws here. Term of the contract can be built into the contract. Terminate, yes. What are the queen? These are the terms. That's why sometimes a little print. These are all the terms always. Term breach of contract. If any party breach it, other party has the right to terminate it. Yes, conduct a treaty if deprived that the innocent party has substantially whole of benefit intended to be received of the performance of obligation under the contract, and this is known as the substantial whole benefit test. So whole benefit test need to be, and the judge will decide, who is breaching for what. Yes, it need to be a serious breach. Is not a breach of warranty. This is a breach of condition. Breach of innominate is intermediate, and the term of the deprived innocent party of the substantially the whole benefit of the contract or repudiatory breach of the contract, and therefore the sufficient serious terminate of the contract. Contract may be set aside of the different standard of breach, such as material breach, fundamental breach, substantial breach. So these are the different types and the kinds of breaches. Any question?
When one party breaches the contract, can the other party request for like compensation, or is it just to terminate it?
No, other party can claim the remedies, because if you are losing the money, yes, so you should be compensated to the stage where you not lose things.
Okay.
So that's that's the crucial elements. So some can be anticipatory breaches when one party express intention to not perform their obligation under the contract and perform the way is the inconsistent with the original contractual. That sometimes they do, sometimes they don't. Yes, so is a breach can. So this is called anticipatory breach. Conduct of the behavior of amount of breach. Yes, maybe either explicit or implicit words, that's, maybe not performed. So there are the lot of case laws as well. When, there is a breach, so it does not automatically discharge the contract. One, the right to terminate. One party has the right to terminate, yes? So, yes, you will pay me damages, but I'm not anymore in contract because you breach of the term of the contract. Yes, you not perform it, your obligations. Okay, especially employment contract. Yes, wrongful termination. If wrongful termination happen, of course, other party, the damages party, have the right to claim the damages. Yes, the party who injured, who suffer it. Yeah, there are a lot of case laws on it. These are all, term of frustration. Discharge of the frustration occur where impossible to perform the obligation under the contract due to the change in the circumstances of the performance contract after it has been signed, such as, lot of, when we say, the fixed rate mortgage, they're always written, maybe we not provide you this rate for next 5-10 years. If there the economic circumstances change hugely and we suffer heavily losses, maybe we can't perform it. Yes, we agree on the 2% fixed rate, maybe rate went to 10%. The bank never ever, will carry on. They say, we are going to terminate. You have a right to choose any new bank lenders, yes, or we will give you on this rate now. Any question?
No.
Okay, example of situation of frustration: subject matter of the contract being destroyed, unavailable, or the contract dies, is serious incapacitated, yes, can be or become illegal to perform. Frustration may not apply to discharge the contract in some cases. Term of the contract we always need to keep in mind, like we have example here, COVID and various other examples here. 4.2 is we can examine the difference between the breach and the condition. Contractual term, either the condition, warranty, innominate term, and these are the contractual term are the classified as either the condition or warranty. The category of innominated term are created in the Hong Kong. For shipping, it is important the parties to be correctly identify which term to be a condition and which term to be warranty. So we have to decide is the warranty or the condition attached with the product. Yes, in these, so we'll do this, and if these product, so or the warranty can be a warranty and guarantees. Any question here?
No.
Okay, condition, yes, is the major term of the contract which goes to the root of the contract. Condition is a breach that the innocent party is entitled to repudiate the contract and the claim the damages, which is happened in that case back in 1876. Warranties are the minor terms of the contract which are not central of the existence of the contract. If the warranty is breached, the innocent party may claim the damages but cannot be end the contract. Contract won't be finished, but the warranty you're entitled. Yes, we not really the service commitment we fulfill, but you can't really cancel the contract like in that case. Innominate term is the approach the established is back in Hong Kong rather than the classify the term themselves. Condition warranty are these attached with the contract. Affect the breach and the question whether the innocent party breach was deprived of substantially whole benefit. The contract only innocent party has substantially the whole benefit can be. So in that case, the benefit can. These are all the case laws what the court said in those cases, which we can include, yes. And these are different, the damages being paid in various occasions. So that's, we can look around these. And then we have a doctrine of frustration, which is our view. In English law, the contract may be discharged only the ground of frustration when something occurs after the information of the contract which render the physical or commercially impossible. We can't do it. Like say we supply something, but the government ban it and we can't do it anymore. So that can be contract can be eliminated. Yes, frustration invoke or mitigate, the Romeus doctrine of absolute contract, where the performance of the contract prevented by the supervening events. Yes, neither party to be contract is responsible and the loss allocation is required. Any question? We can use different tests, and the court can use the different tests. Why this happened? Is it there anybody's control or not? And then decide, what legal aspect, in terms of giving the damages. These are all the English laws and which is we've been given. And we've been given these case laws and we have a reference there. So when we do, 4 point and we can refer these and we can use, these in our assignment, these references. Any question?
Wait, when they had one slide to say test the frustration, how would you do that?
Okay. So first suppose, so you have to be look around the circumstances why this happened. Yes. We agree between one and two things we should perform it, but one party not perform it. Yes. Other party is being frustrated due to and they are entitled for the damages. Yes. So you have to do the test. What were the reason behind that not performing it? Yes, like the COVID-19, yes, is a lockdown. So really, if we can perform it, no. Other party has the right, of course, but not maybe entitled for this for the damages because that wasn't individual control. Yes, and that test we need to use at that time. Is it every industry affected due to, or is it just one industry was? Yes, this lockdown really put it, so that test can be used, the frustration and injured party can claim it. This is all about. Any question on this one?
No, I'm good.
Okay, so these are few case laws, please go through and then when we'll do the assignment so we can refer some case laws under each area. Okay, so today we discuss about LO3 and LO4. So next lesson will be whole assignment and we'll go through from structure how we can. We'll go through from reference how we can. We'll go through how we can answer each question. Yes. And then of course, how you can write it your own words. All will be discussed in the next lesson. And I'll give you 3-4 samples as well. Those you can use it. That will also help you to be prepared and your own words. Any question, Mary?
No, I'm good.
Okay, brilliant. Thanks for attending today's session. This is about LO3, LO4, and a full, LO3, LO4 recording is also available. I'll send you via email as well, and hope so speak you on Friday when we'll do the assignment discussion session.
Okay, thank you.
Thank you. Have a nice time. Bye-bye.
Goodbye.